Let's go over what the new Title II regulation has to say about accessibility statements. On the screen with me is an advanced copy of the final rule, and we're on page 273, and I will link to this PDF in the description. I'm going to read through an excerpt that is a few sentences long, but there are three important parts to this excerpt that I want to cover. So it starts out, it is helpful to provide individuals with disabilities with information about how to obtain the modifications or auxiliary aids and services they may need. For example, while not required in this final rule, a public entity is encouraged to provide an email address, accessible link, accessible web page, or other accessible means of contacting the public entity to provide information about issues individuals with disabilities may encounter accessing web content or mobile apps, or to request assistance. Providing this information will help public entities ensure that they are satisfying their obligations to provide equal access, effective communication, and reasonable modifications. So let's pull forward these three parts I want to focus in on. First, it is an accessibility statement is not required. In this final rule, the DOJ touches on accessibility statements a few times, but this is the most definitive language where we clearly see that accessibility statements are not required. But then, right after stating that accessibility statements are not required, the DOJ then basically encourages an accessibility statement, or at least a way to contact the entity about accessibility. And what we see is they are referring to a way to provide feedback or request support. And we saw this from the consent decrees, from the settlements that resulted from private enforcement actions over the years that the DOJ has taken against various entities. We saw the DOJ require this in the settlements, but here they're not requiring it, but then they're encouraging it because it can help, right? It can practically be a benefit. And then the DOJ states that it can actually help ensure that the entities are, the public entities are satisfying their obligations, so their mandates under the Americans with Disabilities Act to provide equal access, effective communication, and reasonable modifications. So, in a roundabout way, an accessibility statement does help aid and really help ensure compliance with the Americans with Disabilities Act, but it's not explicitly required. Again, I want to remind you that we are reading through Title II regulation, which Title II pertains to state and local governments. But this is important for everybody because with this Title II regulation, we are likely to see several themes carried over from Title II to Title III when it is eventually published. But for now, under Title II, there is no requirement for an accessibility statement, but you likely want to have an accessibility statement because of the reason the DOJ's outlines. Also, just for practical reasons, you want to ensure that someone can get help if they want to, not just for legal requirements. And then also, there is the potential that it will help you avoid private litigation. We know plaintiffs' lawyers have actually made note of the lack of an accessibility statement in complaints filed in court. So, what does Title II have to say about accessibility statements? Well, it really encourages the what an accessibility statement is for, but it doesn't go all the way and requirement. The DOJ did not want to go that far, but there is a lot of upside to having an accessibility statement. And so I recommend it's still a best practice to have an accessibility statement. The two key components remain the same. They are to provide at least one method of contact or for support and or for receiving feedback, and then making sure obviously that that method of contact is live and that someone will receive a response in a timely manner. But this is what Title II has to say about accessibility statements. I will include links to resources below, including my accessibility statement template.